Good afternoon, and thank you for coming today. My name is Shannon Bond. I am the chair of the Intellectual Property Section Council. I am an enforcement attorney for the Illinois Department of Securities, and I am also today's moderator. I began serving on the council and continue to do so. Louder? All right, let's try this then. Thank you. I began serving on the council, and I continue to do so because I think that sharing knowledge and experiences in a collegial atmosphere is one of the most important things that attorneys can do. This event was planned with that in mind, so without further ado, let's get started with our questions. Our panelists have a lot of knowledge and a lot of experience to share with us. Please let me introduce Danielle Egan-Miller, the president and owner of Browne Miller Literary Associates, Chicago's long-standing premier independent literary agency. We also have Bob Labate. He's an entertainment attorney in the Chicago office of Holland and Knight and an adjunct faculty member at DePaul University School of Law. And we have Aaron Nevius, an associate director of book publishing for the American Bar Association. Danielle, why don't you get started by telling us a little bit about what you do?
Hi, I'm Danielle. I am a literary agent, and I did not go to law school. So what I do is I represent authors' work to publishers. I have a clientele of primarily adult fiction writers. I sell commercial fiction, genre fiction, select nonfiction projects, as well as young adult and maybe some middle grade. What I do is, like I said, represent authors' work to publishers. I'm the person who works with an author to prepare their material for submission and sale. I make the matches between editor and author. I negotiate their contracts. I try to reserve as many rights for them as I can, and then I try to exploit those rights on their behalf. I have a business relationship with my clients, so all their earnings related to their books flow through my agency, and I get a commission off the top. I work completely on spec, so I don't charge fees. We are a very editorially focused agency. My own background is as an editor, which means we work with our clients till we feel their books are submission ready. And we're really, I would say, more career partners. It's more than just deal making. It's really about what your goals are as a writer, where you want to be, how you measure your own level of success, and how we can work together to get you there. I don't know what else. Any questions? I can. Yes?
How do you edit for style versus substance in the kinds of work that you do?
Please repeat the question.
Sorry. I'm asking, how does she edit for style versus substance?
I think first and foremost, I have to be comfortable with an author's style. My job is not to tell them their style is wrong. It doesn't mean I necessarily like it. And one of the benefits of being an agent is I pick and choose the projects I represent. And if the writing itself doesn't speak to me, it's not a project for me. Substance-wise, I think it depends on the story and the type of book it is. So like I said, my own background is an editor. We do work at a very detailed level on projects that we represent. So, and we have a track record. Our clients have a very high track record of success. So, I think for the New York houses, which is who I sell to primarily, places like Simon Schuster, Random House, HarperCollins, major national publishers, it's incredibly competitive. And the expectation is that what is submitted to them is as close to publication ready as possible. So that's what this is. I think this has become more so the expectation in the last several years. Editors don't want to buy things that are huge projects. They want to buy something they can publish within the next 18 months. So.
Can I ask two questions?
Yep.
First, I get calls every week about people who want you. And they say, how can I get an agent because you are the gatekeeper? And I tell them, you're the gatekeeper. So A, how can an author be more attractive to you? And two, do you have a genre that you either prefer or aspire to?
I think there's a lot of answer to offer up here. I think first and foremost, if you are looking for an agent, you have to be truly ready and know that you're ready. If you are a first-time novelist, your manuscript needs to be completed. I cannot sell a debut novel on anything but a finished, polished manuscript. So truthfully, it's because nobody believes you can finish it. And so if you call me up and say, I've written 3 chapters of what I think is going to be a great debut, Danielle, can I, will you take me on? Like, well, call me in a year when you're done. And I likely will never hear from you again. Or maybe I will. But, I mean, we don't believe it. I think you have to be ready so that you feel good about what you've completed. If you're writing a nonfiction book proposal, that you've done just that. You've done your homework. You know what a proposal contains. You know what you've written. I think one of the key mistakes a new author makes is they don't really know what their book is. So it's a mystery that could be a young adult novel, but maybe a grown-up book. It has some paranormal elements and a love story, and it's an international thriller.
I love this book.
Yeah, it sounds perfect. And I think you need to know what it is. Once you're ready, the way to address or to look for an agent is to send out a query letter. This has become very much an email-driven enterprise now. Most agencies, mine included, have websites. We have Facebook pages, Twitter feeds. There are industry organizations in which we're listed. There's a number of ways to find an agent. I think you also need to, again, do your homework so the agents you decide to query are agents who represent the kinds of books that you've written. I don't represent children's picture books, and I receive queries every day for children's books. My agency receives probably 300 queries a week, and that's all email. So, I mean, we're getting, 1,200 a month? Do the math. We're getting tons and tons of emails from authors asking us to consider their projects and take them on as clients. The other thing is, your writers dazzle us in your query letter. I mean, if you've spent the last year and a half, or 2 years, or however long, working on this project that you really want to see, be published, or you want to contract with a major publisher, really think about how you're pitching it to me or to other agents in your query. Email tends to give people license to be casual and to be sloppy. I have really received a query email that says, hey, do you want to look at my manuscript? No, I don't. And, people spell my name wrong. They, it's professional correspondence, so it should be reflective of it, how carefully you want to pitch your book to me. I think if you're writing a novel or you've written a novel, you kind of have to be able to, pitch it almost in the way jacket copy is. You know how if you're in the bookstore and you pick up a book and you read the back cover and you're like, okay, I think I might buy this because sounds really intriguing. That's what I want to see in a query, is grab my attention. So, yes?
How many manuscripts do you review or get or read a month?
I would say of the 1,000+ queries I get a month, we probably ask to see pages on less than 10. So, I mean, it's that competitive. I know what I do best. I know what kind of books I'm looking for. I know what kind of books I like. Again, that's why as authors, if you've written a political thriller, target agents who represent other political thrillers, because this is a genre they actively sell. So I think, yes, sir?
Wait, just one moment. Everyone who has a question, if you could just wait and take the microphone. We also are recording this, and your voices will not be heard if you don't have the microphone with you. Thank you.
Thank you. Since Illinois doesn't have a specific literary agent law, I've been called upon to contact publishers for writers, and I always get the answer back, we only go through licensed literary agents. Are you licensed in New York or LA, and how do you do it?
I've never heard someone refer to as licensed literary agents. Anyone can hang out a shingle and say they're an agent. It's,
Oh, no, I know
there's
that.
no certification. There's no, and
They have it in New York and L.A. though.
I don't think so. I don't know. I mean, I'm based here. My experience is I learned the business from an agent who is a very reputable agent. I was an editor for a number of years. I'm a member of what's called the Association of Authors Representatives, which is an organization you're invited to join based upon your performance in the industry. And if you're an AAR member, you have to conduct your business per their code of ethics, which deals specifically with how you manage client funds. Agents get bad names by stealing authors' money. So,
Thank you. I've learned a lot from that. Thank you.
All right, let's go to Bob. Why don't you tell us a little bit about what you do?
Okay. Pain, suffering. I do a lot of entertainment, which means I do film, I do television, I do some publishing, we do music, and we do it on a national basis. A lot of our clients aren't in Chicago; they are elsewhere. So we get a pretty broad spectrum. With respect to publishing specific, we get a lot of inquiries, which is why I asked, from first-time authors saying, what's going on? One of the things that's very attractive about publishing is it's a very disruptive industry. I mean, it's not quite as disruptive as music, but all of the paradigms and all of the ways people made money 10 years ago, Amazon has just tossed everything up and down. Now, that's good and bad. It is either the best time to be an author ever, or it's the worst time to be an author ever. And I say it's the best time because 30% of, statistically, Amazon says 30% of the bestseller list is from self-published authors. And so you don't need to go through the old system of finding a publisher. There are even websites like Unbound where you can, it's called mass customization and crowdfunding, where they will put your book on the site, and then if it gets supported, they'll publish it, which is, mass customization has been around for a while. Dell Computer did it in computers, and everybody's moving towards it, and why not in publishing as well? Crowdfunding is a whole other area. The thing that's I find very interesting is that it's all about social media these days. That if you want to be an author, you are first off a social media guru. You know how to talk directly to your audience, to your readers. A lot of people, including 50 Shades of Grey, started off on the internet, started off in serials, started off small, and then grew and grew and grew. And so if you like disruptions to an industry, this is your industry. If you like things to be the same, this is not your industry. The good thing is that it is about what you don't have to find an agent, although if you find an agent, they are the gatekeepers. They are the professionals. Everybody wants you. I'm also writing a book on the legal elements of film law with an ABA publisher. So it's painful. So those of you who are writing books, I share your pain.
Not because of us.
No. The only reason it would ever see the light of day is because Lisa, my editor, she's just absolutely wonderful and her comments from me. But that's, like everything else in entertainment now, it is disruptive. And if you are willing to be disrupted and go with social media and understand what it's about, this is a great time. If you don't, if you want somebody else to do your work of communicating with your audience, this is not such a good time, so you may not want to do this.
Does anyone have any questions?
I have a question, but it's more associated with copyright for Mr. LeBate.
Oh, I don't do law, I'm sorry.
I'm curious about the requirements of other agencies and the impact that they may have on copyright. For instance, ASCAP requires that you have a name that they're happy with. And then when you publish the sheet music, it has to say that specific statement so that they can find you and pay you your royalties. My question is, if something exists previously copyrighted, what kind of impact does that sort of requirement from a third party have on publication?
All right, this is chapter 3 of my book. It's so exciting. Yeah, the 10 elements of copyright. Basically, copyright is in flux. As to ASCAP, BMI, that's for public performance. I mean, it's a very narrow thing. It's outside the scope of what we're doing right now. If you own a bar, you better get a license from ASCAP, BMI, money which goes to the owners of the music. But that's fairly narrow right now. What's more interesting is dislocation with respect to Pandora and other things. But stay tuned for the next seminar, because that's a really cool, and then we'll have music. We'll have music attorneys who will do that. As to copyright, what we do with our authors is you have to get something called E&O insurance. If you don't know about E&O insurance, it's called errors and omissions insurance, right? Oh, wow. You're blessed. Yeah. E&O insurance basically says if anything goes wrong with this, if someone sues us because you have taken someone else's copyrighted work, if you have quoted somebody else's copyrighted work, and there's a new case, I'll remember it in a second, where there's a verdict in the Southern District of New York where 8 photographs were taken from let me go back. I have a tough time with linear stuff, so I'll try to do this. My students understand this, but I'll go back. Moreau. The case is Moreau, and it's Moreau versus Agency Presse Française. Essentially, there was a photographer who happened to be in Haiti during the earthquake. He took 8, and I'll tie this up. This will all come back to publishing. Don't worry, I'll do this, Your Honors. And so he took 8 photographs. He posted them on Twitter. And then another photographer said, hey, these are great photographs. I'm going to put them out under Twitter under my name. He had a contract with Getty or some, I may be getting some of these names wrong, and Getty then gave it to Agency Française, and then it ended up in the Washington Post. And within 24 hours or so, the owner of the photograph, his agent said, hey, our photographs are being used, you need to stop that. And so the facts are a little confused, but long and short of it is they were still in the Washington Post about 3 months later. Moreau then sued for copyright infringement, and it's up to $30,000 per each kind of just negligent copyright, and it's up to $150,000 per willful copyright infringement. $150,000 per work. And so the jury came back with, and it went up, to clarify some of the laws, but essentially the jury came back with an award of about $1.5 million. And that's now up on appeal. That whole issue as to whether the willfulness was sufficient. All the lawyers will understand the problem with that. That has sent a chill through newsrooms everywhere because you have 8 photographs costing $1.5 million to the news agencies. Now, how do I tie that back to what we're talking about? Well, E&O insurance basically says you go to Chubb, you go to Beacon One, 2 of the very good ones, and you submit your manuscript. And you fill out a lot of questions, and you basically say, I'm not using anyone else's copyrighted work. So the example I gave you had to do with photographs, but it could equally apply to taking portions of somebody else's book. And there's a whole thing about, but it could apply to any portion of the book that you take from somebody else's copyrighted work, which copyright still exists. What they would do is that could cost you. And so if the person who owns the copyright, pre-existing copyright, sues you, then you really don't want to pay for it out of your own pocket. You go to the insurance company and say, well, please pay for this infringement action, or a defamation action, or false light, or any of the other torts that exist in Illinois or other law. And so when you submit your manuscript, you're probably, unless you have a license for everything, or you've made up all your own illustrations or drawings or whatever, you're going to have to get an attorney to give an opinion letter to Chubb or whatever and say, we reviewed this. There are certain portions which are not completely licensed, but we believe that they are fair use. And you go all into fair use and whether it's the First Amendment will predominate over copyright, and those are really in flux. There's wonderful cases. If you want to have a good time, you go look under fair use and right publicity and copyright. Wonderful writing stuff out there. It's terrific. Did I answer your question? Oh, there's a question over here.
Okay. So, since we have to use social media and everything's in flux, how do you protect your intellectual property? So, for example, if you have a book and you have a name,
Yep.
then somebody goes and buys your domain name, and they want you to have to buy it back from them. And then also, a lot of your work gets uploaded for free on Google. So, what do you do about these things?
Okay, there is the Digital Millennium Copyright Act, in which if your copyrighted work is being used elsewhere, you can send a letter to, and it's a very formulaic kind of letter, which basically, we use it all the time. And it's basically a cease and desist. Well, it is a letter to the internet service provider, and it's a takedown letter. It says, take down this work. It's my work, don't do it. And it's formulaic, and if you say, I'm the copyright owner, and this is where it appeared on your website, and this is what I own, and so on and so forth, in formula, then they will take it down immediately. So that's one way to protect your copyrighted work, but that assumes that you have registered the copyright. Now, copyright.gov, the website, is our best friend. It costs minimal amount to register your copyrighted works, be they literary, photo, whatever. And go to copyright.gov website. It has wonderful materials that tell you exactly what you need to do to register your copyright. It's so easy. And oh, by the way, here's one of the little secrets. If you have registered the copyright before the infringement, your attorney gets paid by the other side. And so that's a really important thing to keep in mind. If you register the copyright after the infringement, you're not entitled to attorney's fees. And, oh, by the way, you can't file the copyright. You can't file the copyright infringement action until you have registered the copyright. So if you are producing, if you're a creator of content and you're providing that, you're registering that, continue to do so, even if it's in draft form, because you can always update it. And we have our authors, our filmmakers, our writers, whatever. We always want them to continue to copyright their work. Ideas, of course, are not copyrightable, and so I tell our people we have to treat it like dating. You do not press send on your email for your idea. There are only 12 original ideas in the world. Shakespeare had like 7 of them. And the copyright law basically says, it has to be sufficiently original, creative, so on and so forth. This is just like class. This is so cool. But you get the domain names. If you then have to challenge someone who doesn't have the right to use a domain name because maybe they have just created a domain name, so you may have to contact directly and say they don't have it, they don't have the use. I don't do the domain name litigation, so I'm not up on the latest of that. But essentially, if they don't have the right, if they're just camping on it, just to sell it back to you, you may be able to recover it. Or you may change it slightly. But it's an issue.
But the thing is, if you miss it by one day, there are these whole groups of
the
people
question
who
is how do
troll.
you protect your domain name? There are lots of attorneys who do intellectual property of that type. We do it, as a matter of fact. So I would contact one of those attorneys. I would just find out who does intellectual property of that sort. Holland and Knight, firm does it. But there are a lot of other firms who do it. And they can probably give you. And I would go on the website. I would go on the internet and look under protecting domain names and see what you find with respect to that. There are international organizations that also have that, and they may have helpful information.
Okay, you talked some about borrowing people's work. What about fan fiction? Because my understanding is that 50 Shades of Grey actually started as fan fiction. And so why don't you tell us a little bit about how that kind of thing works? Is that a good idea? Should I have a great idea about some movie out there and then decide to write some fan fiction?
Okay. The way you would normally do it to be a conservative attorney is to, if you have fan fiction, then you would register the fan fiction with the U.S. Copyright Office. Right? Fan fiction is simply, my daughter can tell you much more about this. She has a number of websites that essentially fan fiction is, I'm writing about another's work. So I like the Harry Potter series. I'll take something that people know about. And so I love the Harry Potter series, so I'm just going to write a little thing about young Voldemort. You know, I think he's a very interesting character, and I think that young Voldemort I really want to write a story about it. But
It's derivative, basically.
yeah, it's derivative, it's infringing, but what happens is that if you're not competing with the original author, then she is, in this case she would likely not care. I mean, if you're going to create the Quidditch game and try to sell the Quidditch game, she has sued and rightfully will protect her intellectual property. But most fan fiction is uncontrollable because it's written by people who are just interested and excited. And what a lot of the networks found was that at first they were very concerned about, I'm not going to allow anybody to mention my TV series, well, movie, whatever. And then they found out that their sales went up. Oh, what a great idea. It's marketing. It's peer-to-peer marketing. People are just, the kids are getting excited. So they will monitor it, but the copyright owners will monitor it, but unless they feel that you're competing with them and competing their lunch, they are not, they generally aren't concerned with it. And then what will happen is if they're concerned about it, they'll send you a cease and desist letter. You know, they'll say, don't do that. Or they'll send you a letter saying, come talk to us. This is kind of interesting. We kind of like this. So, don't do music sampling, but if you're going to do fan fiction, be interesting. Do it interesting. And if there's a worry about it, then they'll send you a letter.
You talked a little bit about self-publishing and then fair use, and I'm wondering how you can protect yourself if you're writing nonfiction, a memoir, and you're using quotations of various sorts. And if you're self-publishing, how do you know? I would assume an agent and an attorney would help you through that, but on your own, if that's not your area of expertise, how do you navigate that?
It's a great question. Because it comes up all the time. We do a lot of documentary film. We are working with like Cartempo, which does some of the best documentary film in the country, and which is Life Itself, the Roger Ebert film. So these issues come up all the time, which is, okay, if you are depicting facts, now, I'm not giving anybody legal advice, I'm making a disclaimer right now, but the general rule is that if you are factually correct in what we ask our authors to do, and the people who do television shows and film, they have to keep a log. Where did I get this fact? Where did this come up? Where did this person say this? Is this absolutely correct? Is it in a book? If you remember the film Midnight in Paris, there was the phrase from the novel which said, past is not dead, it's not even past. Well, Woody Allen got sued for that, for using that, and the judge said that is fair use. So if you Google, again, the internet is your friend, you will find let's go back. Let's do this. Fair use is defined in the U.S. Copyright Act, and it's a 4-part test, and it is very difficult to balance. There is no bright line. No one can tell you that this is fair use, this is not fair use. If you're doing documentary film, there is something called the best practices in documentary film, and that will give you some bright line, even though no court has accepted it, insurance companies have it, so that's almost as good. And so basically you want to see the 4-part test for fair use, go to Midnight in Paris, and then district court, I think it was in Mississippi, and that case will come up. And essentially it says, how much did you take? Was it the amount? Or was your use transformative? Now, if you're doing nonfiction, then it's not transformative. When I think transformative, think of Mao Zedong with lipstick. any Warhol kind of pictures, making things transformative. That's a big issue. And then, did the use of this create a new market that took away from the others? It's not quite, did you take the market? Did you create a market for yourself, or are you simply riding on their market? There's also some case law on the Wind Done Gone, which was a parody of the what is that? Getting old has its benefits, but it also takes me a while to retrieve information. So if you go to the Wind Done Gone case and other parody cases, you'll find out. Also, there are websites that talk about parody. Parody is protected if you're doing a real parody. And I won't get into those cases, but there are some wonderful, wonderful cases about parody that talk about the use of somebody else's work, but you have to transform that work. If you're just taking it and just using it, then it has to be absolutely accurate in what you use. If you're taking someone's literary work, you should ask for permission. Do you need the permission? No. If you're taking a very small amount and you're not affecting their work, that's fine. But understand that if you're taking someone else's creative work, that's infringement. And you're impaired in your fair use as an affirmative defense. If you're just taking someone's quote, then that's generally protected. That is, particularly if it's of public interest. So if you have something that's of public interest as well as being factually accurate, you're usually in pretty good shape. But if you're writing, you really, really, really want to get an attorney to go through it with you, because she'll have to write an opinion letter to your E&O insurance provider saying that this sentence has been used on this page in this context and under the applicable rules of fair use. It is protected. And based on that, you usually get E&O insurance, so if somebody sues you, then the insurance company pays. Does that make sense? This question is who pays? It's always who pays, who bears this.
Can I chime in on this a little bit?
Please.
Okay, remember, I'm not a lawyer, so I'm all about the practical of what's real. First of all, a memoir is your personal story. So you have to ask yourself, why are you depending upon verbatim text from someone else in your story? Number one.
Oh, she's in.
Oh. Okay. Okay.
And very truthful.
And again, if this is a memoir, which is, a creative nonfiction work that looks at an episode of your life through hindsight, through, et cetera, where there is, from a commercial standpoint, an expectation that the telling of the story and the drama of the story itself is really paramount to what makes it of interest to readers. Why are you depending upon quoting other people's work, and at what level? Okay, that's one thing I would ask just as a writer to think about and reflect on.
And I'm just going to add, if you're just telling facts,
Yeah.
there is no one owns facts.
Right, exactly. No one
owns
owns facts.
Only the way you use the facts, provided that you do not use someone else's description of the facts. And if all you're doing is facts, that's not protectable under copyright. And then you have to worry about, well, is it a tort action? Is it false light? Am I exposing myself to defamation? That kind of thing.
Where
If they're facts, they're facts.
where I see, again, as a creative work, where I see quoted text often in memoirs are using song lyrics or poetry as chapter openers, that kind of thing. I typically advise authors, don't use song lyrics because they're almost always permissible and you have to pay for them. Poetry, it's got to be public domain, just from a practical standpoint. And I represent authors, so my authors don't, get E&O insurance. When they sign a contract with a publisher, there is a very lengthy warranty and indemnity clause in a publishing contract, and any insurance or insurance writers are held by the publisher. And which means that if there is a copyright infringement, accusation, it doesn't take much. Someone can write a mean letter and say, I came up with this idea 10 years ago and you ripped it off. That's enough to set a whole bunch of things into motion. And what we try to protect is that the author's royalties, et cetera, aren't going to be held up by someone making a baseless claim. There is a presumption that if you are signing a contract with a major publisher and you are reading through the warranty indemnity clause, that you understand if you are plagiarizing, if you are, using other people's work without permission, etc., that you'll be held responsible for it, and you'll pay for it, and it can affect the saleability of your book, and certainly the ability for that book to stay in print. So, but for a self-published, I think you just have to use, in my opinion, you have to be sensible, and I don't know if it makes sense to go through an expensive legal vet of a, self-published memoir if you can check yourself and say, okay, and to cover yourself, I would include an author's note at the end that includes a list of your sources.
Inexpensive and very valuable.
Yes, I don't disagree. I don't disagree. So.
Where in this could be for either of you, I guess, where in the process would you actually copyright something? Is it you copyright the first draft or the finished product, or if you're going to submit it to an agent for editing or whatever, where would you actually do that?
Some authors choose to copyright their work as they're writing it, as they, when they finish it before it's published. Again, if you are looking to be published by Random House, etc., Random House is going to register the copyright in the finished work, which is the Random House edition that they'll be publishing, typically in your name, and they go through the whole exercise of that. From my vantage point, it's not necessary for you to be registering it along the way. Many authors choose to do so. It's fine. I think
most publishers will start the copyright process when we have a manuscript in the highest unit. It's with the Library of Congress, and it's called cataloging and publication, and all publishers do that.
What are you doing? You're all probably too young on their car 54 already, but the big thing you have to worry about are people who will take your published work and transfer the copyrights to themselves. I just saw this earlier this week, where the publishing agreement looked like a fairly standard vanilla publishing agreement, but the agreement said publisher will register the copyright in publisher's own name. Well, that's not a good thing. So when you're looking at publishing agreements, and there's vanity presses out there, and they'll print whatever you want them to print. But there are also a lot of publishers who will say, we'll publish your book, or we'll sign this agreement with you, but it becomes our property. And that is no. Go right to the copyright section of the contract.
I want to come back to that, but Erin, this is a good time for you to go ahead and tell us a little bit about what you do as well.
Sure. Hi. First and foremost, thanks everyone for coming out and being so engaged. This is really wonderfully validating for those of us in the publishing industry that you're also interested. I'm Erin Nevius. I'm the Associate Director of Book Publishing for the American Bar Association, and pretty much what that means is I'm a product developer. It is my job to acquire titles and authors into a relatively specific list of books. I actually did not go to law school myself either. I have a trade publishing background. And 6 years ago when I moved to the ABA, I've described the transition as moving from writing free-verse poetry to writing science. You can be just as creative, there are just more boundaries as to what you can do. So I personally do about 25 books a year. 50% of those come from agents or unsolicited over the transom proposals. 50% are things that I've identified for our line, and I will go out and try to find you. So the more visible you are online, the easier I can stalk you and eventually contact you. And the ABA in general does about 200 books a year. We are in a phase of significant growth, which has been really exciting. 75% of those books are, of course, practical how-to prescriptive guides from practicing attorneys to practicing attorneys. But because we're growing so much, we're exploring a lot of other things, including consumer guides. We're doing an LSAT prep book this year. We're doing consumer guides to short sales. We are doing a novel, David Lack's first novel, Above the Law, is coming out in September. We're doing some true crime books, and we do a lot of historical nonfiction these days. Civil War law and lawyers. We're working on Cold War law and lawyers right now, which unfortunately the situation in Russia, I think, has made more saleable than it may have been. And we also do the occasional kids book. We did a book on constitutional law for kids, and we actually have a line of feature books. So I would say, feel free to contact us about anything. I will talk about anything, any idea you have with you. It may not be the idea that you originally proposed to me, but there is every eventuality that we can land on something.
Does anyone have a question for Erin? Okay. Well, what I'm wondering is, how do I make my work stand out? You said that anyone can contact you, but what will make that person seem extra special and something that you'd really be interested in following up with?
Sure. Well, first and foremost, we want you to have a demonstrated expertise in the area. And this does not mean you have to be the preeminent scholar. It does not mean you have to have published before, though it helps. If it's a practice guide, we want to know that you've been practicing it for a while and you've seen it from a lot of angles. Second, we are extremely interested in identifying emerging legal topics. Practicing lawyers are people on the ground. You see what's coming down the pike before anyone else. So if you identify something that's going to change the way people practice, going to change the industry, going to be just a new thing, we want to hear about it and we want to be the first to market with it. If your book idea is not that, if it is something sort of tried and true, what's your unique angle? What do you know that other lawyers might not know and would really want to know? And finally, we're looking for passion and platform, just like anybody else. We want you to be pretty adept at social media. If you do CLE presentations, speak at events, meetings, all that stuff, that's great. But really what we want to know is that we're going to have a dedicated partner throughout the marketing and promotion process. You guys know your market better than anyone. So we need your insight and we need your participation.
Can I just ask, how long does that process take?
From the acceptance of a proposal through published
Right.
book? Well, it all depends. Writing process can go from 6 to 18 months, usually. And I'm totally with Danielle on this. I don't have to see something finished, but I want a pretty good indication that you're going to finish it. So after the writing process, I get the manuscript. All of our books are peer-reviewed. That is something that makes people nervous, and I like to reassure everyone that peer review is not about changing anyone's voice or opinions. It is about a substantive law check. Mostly, I don't even let them write in the manuscripts. Just send me an email on your thoughts. I will pass it along to the author. Peer review takes about 6 weeks. At which time usually I'm doing my edit as well, which is a developmental edit. Flow, readability, organization, covers everything that in the agreed upon outline, that sort of thing. All of that goes back to the author for revisions. Usually takes about a month, and then we launch the book into production. Our production process is extremely fast. It's 4 to 5 months. Most publishers, it's closer to 8 to 12. So 4 to 5 months later, and you have, you review the copy edit, which is style, grammar, that sort of thing. You'll review the designed pages. Then the book is indexed. You look at cover designs, and you're done. So once it's in my hands, it's about a 6-month process.
And I can just testify that the peer review process is not that bad. I went through it myself as a contributor and editor for Careers in IP for ABA Publishing, or a part of ABA Publishing anyway. So yes, it's something that you should definitely look into, and I recommend it highly.
I have a question about privacy law. If you're working on a manuscript that's a memoir, and you're showing some people in some negative light, but it's all accurate, it's all true, is there a good primary source material that you could recommend so that the author does not cross over into violation of privacy rights?
I'm going to turn this over to the attorney.
Okay. Privacy law is a very big tent, and we can either be talking about tort, which is defamation, false light, and there's been at least one case, not in this circuit, that basically says you can tell the truth, but if you do it in the wrong order or you create the impression, then that's actionable and may go to trial. So not only do you have to tell the truth, you have to make sure that you're not editing it in a way that creates a false impression. There are all kinds of issues with respect to the tort itself. But basically, let me go back. Basically, if you tell the truth, you're going to be on good ground. Now, where did you find that truth? Is that a public truth? Is that in public documents? Or did someone whisper that in your ear? There is still public exposure of private facts, and that can get you into big trouble. And when I say big trouble, I mean it gets you sued and it doesn't get dismissed immediately. And we had I'll go into film, we had a film crew filming and it's The Interrupters, it was for Temple, where they're filming in a funeral at the invitation of one of the participants in the film, one of the subjects of the film, and we got sued by somebody else who was there and said you're intruding into a private thing, even though it was perfectly open. So anyway, stick to the facts. Do not defame anyone. If you don't know the facts, find out the facts. And I'll tell you from a procedure-driven, when you have facts about other people, you have your book. Do what we do for TVs and docudramas and things and documentaries. Where did you get these facts? Who told them to you? Do you have a lot of sources for them? Are these facts actually correct? So and if you can give that to the other side, then that usually makes it go away.
Do you recommend having more than one source, for a fact?
Oh, absolutely.
Like with journalism?
That gets you out of the public disclosure of private facts. Now, I only gave you one aisle of that church. The other church has to do with right publicity. Right publicity is a state-by-state statute, and sometimes common law. Some states have statutes only, some have common law and statutes, some have just common law. And they're all different. So but generally if you're writing a factual depiction, you're okay, because right publicity, if you look at the right publicity statute, and Google right publicity Illinois statute, you'll come up with some lovely case law, which goes all through the Right Publicity Act. There are exclusions for factual statements, for non-commercial uses, that kind of thing. Oh, by the way, recent case law is saying non-commercial use includes a reality show. There's a wonderful case involving female force, in which the crew took pictures of a woman who was inebriated, and so she sued for Right Publicity, and decisions came out against her. Judge Kemble, maybe just find some lovely case law on that, lovely case decisions on that, very well thought through. Did that answer your question?
I guess I did. I'll let someone else speak.
Okay.
Yes, you had touched on this
A lot
matter.
of things.
On this matter a little before. A while ago, I was talking to a friend of mine who said that when you submit a work to a publisher and they agree to publish it, that the publisher actually gains ownership over the material. Now, I was just wondering, now you had said that that sort of depends on, I guess, the reputability of the publisher you submit the work to. So is that the case, or was I misinformed? And to what sort of degree does the publisher own the work that you submit to them to publish?
What you typically grant to a publisher in a publishing contract is the term of copyright for their publication interest in the work. The author can retain the copyright, but the publisher is basically buying from you or licensing from you the work for its term of copyright. So it becomes, if you're selling your book to Random House, it becomes, the Random House edition that's published. You are still, copyrighted by Joe Smith. But how you get those rights back is what is also detailed in the contract for a paragraph on termination or out of print, etc. And that has become a huge hot button issue now with ebooks, because authors who have works that have gone out of print, the rights to the work don't automatically revert to the author. You have to have the rights reverted. And that is it's a very challenging process these days. Most authors want to be able to re-release their books on their own, on Kindle, through Barnes & Noble, etc. But just because, the Random House edition that was published in 1995 is no longer available for sale doesn't mean that they've relinquished their ownership of the rights to it. So that's something that we spend a tremendous amount of time negotiating on in publishing contracts now.
I'm going to add a few thoughts. You're going out of the tent of copyright, and you're going into contract. And so essentially what you're doing when you enter into a publishing agreement, you are giving the publisher an exclusive license. An exclusive license, basically, in the copyright law allows that publisher to enforce the copyright in your name. If it's a non-inclusive license, they would not have that right. So you'll be giving an exclusive license, and then you'll look very carefully at that grant of rights section, that big, dense, thick paragraph that says grant of rights. And that is everything they get to do for the copyright, which I believe is life and being plus 75 years, so it's a long time. And they exclusively get to use the material you've submitted to them, unless they give it back to you, or as she said, it reverts back. And there's another long, dense provision under reversion, and the question is, what are the elements of reversion, and at what time you get, and do you have to pay for those reversion of things? So understand it's a contractual right that you're giving to the publisher, as long as you're not assigning the copyright. And there's also something called reserved rights under your publishing agreements. And so I'm giving Amy will give to the publisher the right to print and e-books and everything else. That'll be laid out. And then there'll be a section called reversion of rights. So I get to keep the movie rights, I get to keep the live theater rights, I get to keep the theme park rights, I get to keep the video game rights. Don't laugh. These are important, except for my law book. Not much theme park there unless you're lawyers and love the ride. But there's a section on reversion of rights. And so you want to take a look at that reversion of rights, or give it to somebody who's been around the block before on this, and see whether you're keeping the rights that you may think are good. The other thing you need to look under grant of rights is who gets to negotiate those deals. Because if it's with respect to the book or republishing of the book, then okay, the publisher can do that. But if it has to do with your film deal, you really want to be involved with that. And there are a lot of horror stories where the publisher had those rights and really just sold to get money, and it went completely away from the essence of the book. Because don't forget, when you grant those rights exclusively, you grant the right to edit, amend, change your book. So you may end up with a wonderful novel about little kittens, and by the time it comes out in the film or TV, they are mega kittens from space who kill everybody. Your characters can be completely changed. Also understand that if you have a character that you want to have on a long series of novels, you really don't want to give away that character, because there are separate copyrights for character, for story, and you have copyrightable elements of your book. So as we say, it's a bundle of rights. And you have to decide which of those individual sticks you're going to keep for yourself. Maybe it's the character. Maybe your little kitten character is something you're going to keep, but you're giving the publisher just the right to publish this book.
Okay, time is getting a little bit short here, but let's take another question. But just know that this might be the last one.
Since most of us in the room, I assume, are lawyers, would you comment on the dangers or the technicalities of the temptation to write about a particularly interesting case that you've had?
Well, from my vantage point, I'm interested in, let's say, a novel that's going to grab my attention. Whether, if you follow the adage, you write what you know, and you create a story that's based upon a real experience you've had as a lawyer. If it works, sure, I might be into it. It just depends. I think you have to ask yourself, is that story exciting to you, or is it exciting to, potentially exciting to the general public? So I think it depends on the overall execution of the work. I think all of us can get caught up in our own work and think it's, we're engaged in it, it's exciting, it's what we, thrive on. That doesn't mean that anybody else cares, truthfully. So if you're...
That's from our perspective, that would open you up to scrutiny. It would have to be presented completely objectively, and I'm talking about trial transcripts objectively. If you are going to fictionalize it, let your publisher know what the real circumstances are, and a reference they can check against, and let their legal department look at it.
I see this all the time in query letters, that I've written a novel that's it's a contemporary thriller that's about, an embezzlement case or banking fraud or something. And I'm an attorney who was actually involved in a case in Kansas City about, $6.2 million or something was stolen. And it formed the basis of what I've now created, a fictional work. I look at it specifically as its merit as a novel. How far you are citing or just you change the names if the facts are the same. At this point, on an initial look for me, I'm not scrutinizing that. And I'm not holding it up to a legal standard because I look at it as strictly as a work of fiction. So, and for me, it has to fly on its own merits. If it's like a John Grisham novel, I'm in. If it's not, it's probably not for me. So.
As we all know, the Illinois rules of professional conduct apply, and your confidentiality provisions apply, and you are opening yourself up to all kinds of hurt if you have based it on a case, because your client or someone who has talked with you in confidence on the assumption that they're your client could bring a very nasty action against you. So understand, it's not just copyright, it's Illinois rules of professional conduct. So, if you were going to do it, do what the TV shows do, which is when they say rip from the headlines, and we've represented some people whose stories were ripped from the headlines and we didn't like it. Then the producers will say, oh no, this story is ripped from 3 or 4 different headlines, not just your headline. So again, let's say procedure, make sure it's based on 3 murder cases. Or if it's in cold blood, make sure it's all public record, and you're not the attorney.
Okay, then it's almost time to go. Can you just very quickly, if you would each just tell us what advice you would have for a writer who's been rejected in the past, maybe when they submitted to a literary agent or to a publisher or something like that?
I think if you want to be a published writer, rejection is part of the process. You have to have a thick skin. There are a million reasons why a project could be turned down that have nothing to do with you personally or sometimes even with the book. I regularly reject things via query every day because it's just not my kind of thing. It doesn't mean that the project lacks merit, that it's something that couldn't have a particular publishing success. It's just not the right fit for me. I think, however, if you're striking out across the board, you do need to take a step back and let me look at my query letter. Am I effectively pitching my book in a way that's making it sound interesting? If people are rejecting it across the board, maybe not. Maybe I can mix that up. Is it not fitting into the marketplace, or have I positioned it kind of incorrectly? I can reconsider that. Or you can just keep forging ahead and keep trying. So it takes a lot of no's before you get to yes. That is the way this business works. I have authors who are now very successful New York Times bestselling authors who were rejected for years. So you just have to kind of stumble upon the right person, the right time, the right project. And, if your storytelling ability or your writing talent is really there, I believe you'll find your opportunity at some point. So.
I would say be really open to critique. It can be a rough universal truth that you cannot see your work from the vantage point of a reader. So listen to your readers. This is how the people who buy your book will experience it. And also just keep writing. There are a lot of different kinds of writers, but there are 2 who are very prevalent. Those who just don't do it, and those who won't stop doing it. So, write as much as you can, know when it's finished, and just keep trying.
The contract I looked at earlier this week was from an author who'd been rejected 30 times. And he finally got a contract, which is a pretty good contract with a pretty good publisher. So it was the 31st was the charm. I will also reiterate that there's never been a better time to get out there in social media, in just publishing on your own. Publish on your own. 30% of the bestsellers on Amazon are self-published.
Okay, thank you everyone so much for coming. We enjoyed all of your questions, and I'm sorry that we ran out of time. Have a good night.